Hare Krishna. Welcome to Tax Guru YouTube channel. This is CEO R. Pingle, practicing chartered accountant based in Mumbai, also partner in Motilal and Associates LLP, member firm of Marks Network. Welcome to the video series What Law Says. And today we are going to discuss one important case law reported to High Court under GST law. And this case law is related to the matter where notices are uploaded on the GST portal. So let's dive into it. Let me allow to share my screen. So what law says? In-depth analysis of case law under GST reported to High Court. So under the CGST Act 2017, services of the notices, orders, or communications, any communication is governed by which section? Section 169 of that. So one of the modes of services recognized by making the notices available on the GST common portal. So, however, a portal issue arose before the Madras High Court, whether mere uploading on the portal, where uploading on the portal with means uploading on the portal without effective communication and alternate modes of means where alternate modes when no response is received constitutes valid and effective service or not. So the court repeatedly emphasized that the compliance with the procedural compliance with procedural law must be substantive and meaningful. Mere mechanical uploading that fails to alert the taxpayer, very important in practice, amounts to what? An empty formality and violates the principles of natural justice. So today's case law is based on this. So let's moving further, let's see what is the case citation. TVL Enfive Systems Private Limited versus Commissioner of Commercial Taxes and another, Madras High Court, Madurai Bench, date of order 18th December 2025. Very latest case law. Let's understand facts of the case. The assessee's so-cause notices that and subsequent reminders were uploaded on the GST Common Portal under Section 169, subsection 1, Clause D of the GST Act. So the tax authorities didn't adopt any other mode of service such as RPAD, register pad, or email, etc. Once no response was received from taxpayer despite repeated portal notices. No personal hearing was granted before passing the ex parte assessment order under given case, resulting in adverse demand against the assessee. So the assessee claimed it was unaware of the portal notices due to which it could not file replies or present its case. Hence, a writ petition under Article 226 of the Constitution was filed challenging the ex parte order. Let's see what was the issue under consideration. So issues were whether uploading GST notices on the GST portal alone without follow-up service by alternate methods or alternate mode of service constitutes valid and effective service under section 169 subsection 1 clause D of the GST Act. And other issues was a GST assessment order passed ex parte on the basis of such portal uploads without personal hearing violates the principles of natural justice or not. So very important. Let's see what are the legal provisions related to this. So relevant provisions, section 169, subsection 1 of the CGST Act 2017, which deals with services of notices, list multiple modes of service, including making the notice or order available on the GST Common Portal. Okay, that is section 169, subsection 1, clause D. And the principles of natural justice, that is mandates that a person should have effective opportunity to be heard before an adverse order is passed. Very important to note what principles of natural justice is mandated. The mandates that a person should have effective opportunity to be heard before an adverse order is passed. So let's see what are the contentions of the assessee. The notices were merely uploaded on the portal and not otherwise communicated to the assessee. Hence, the assessee never become aware of the proceedings. Because of this lack of effective communication, they could not reply to the show cause notice or avail of a personal hearing. The ex parte order was passed without proper service and hence violated the principle of natural justice. Now, let's see contention of the revenue. Uploading of notices on the GST Common Portal is valid mode of service under Section 169, subsection 1, clause D, and thus sufficient is what contended by the revenue. And once notices are uploaded, service is deemed complete as per the statutory provision, is what contended by the revenue. Let's see what High Court observed and held. The court recognized that portal upload is a valid mode of service, absolutely, under Section 169, subsection 1, clause D, because the statute expressly provides for such mode. However, the validity of service must be distinguished from the effectiveness of the service. Very important. Please note this. The validity of a service must be distinguished from the effectiveness of the service, the objective being to meaningfully inform the taxpayer. When repeated notices are uploaded to the portal but no response is received, the officer must apply his mind and explore other modes of service prescribed under Section 169. For example, register AD, email, speed post to ensure actual communication. Mere mechanical uploading is an empty formality. They use the word mere mechanical uploading on the portal is an empty formality. So if the officer fails to adopt such alternate modes and proceeds to pass ex parte orders without affording personal hearing or ensuring effective service, it amounts to what violation of natural justice. So in such circumstances, the court held that ex parte orders passed in such a manner cannot stand and they must be set aside with directions for fresh consideration after effective service of the notice and hearing. So, what principles laid down by this case law? Portal upload alone is not equal to always effective service, while uploading notices on GSTN portal is what legally recognized mode under Section 169. It may not constitute effective service in practice if the assessee remains unaware. So, due to explore what alternate modes. If no response is received from the taxpayer after portal upload, then the tax officer should apply his or her mind, explore other statutory modes such as register AD, email, or speed post to ensure what actual receipt. Application of mind required, as I said. Service of the notice should not be treated as a mere procedural formality. Officer must use independent judgment to ensure meaningful communication. Natural justice cannot be compromised. Impugned order should be set aside if passed without ensuring the effectiveness of the notice and personal hearing were required. Empty formality criticized. Sole reliance on ineffective mechanisms designed merely to tick procedural boxes creates future litigation and undermines what the purpose of the law. So conclusions that GST portal upload is a recognized mode of the service. It cannot be treated as a mechanical exercise. Effective communication and real opportunity to respond are essential. So the Madras High Court has delivered a significant jurisprudential stand on the service of the GST notices. Recognizing that the portal upload is a legal mode of service, the court has simultaneously reaffirmed that the legal validity must be complemented by the practical effectiveness. tax officers cannot treat service as a mechanical formality, especially in cases where the repeated non-response indicates that the assessee didn't actually receive the notice. The judgment strengthens what the principles of natural justice under GST law by insisting an effective communication, a core requirement of fair adjudication. Consequently, where an assessee has not responded to the portal notices, the revenue must adopt alternate modes of communication before passing any orders that may adversely affect the taxpayer rights. So that's it for today. Thank you. Thank you so much for patient hearing. Please note down my contact numbers. If you have any suggestions, queries, observations, then do let me know via email, WhatsApp, and you can also comment below the video. So stay tuned to the Tax Guru YouTube channel. If you're not yet subscribed, then do subscribe for latest updates and video series like this. Thank you. Thank you so much. Bye bye. Take care. See you soon. Hare Krishna.